The Trump administration has finally issued its response to the ongoing challenge against Missouri's Second Amendment Preservation Act that is currently before the United States Supreme Court. In their filing, the administration stuck with its earlier position, arguing that Missouri's state law is invalid and urging the Supreme Court to deny review of the case. But what makes this situation even more important is the fact that things have shifted recently in a major way. Because of political changes that just unfolded, the trajectory of this case may not be as straightforward as it once appeared. So let's carefully unpack what is really happening here. At the center of all of this is Missouri's Second Amendment Preservation Act, a law passed in 2021. Second Amendment Preservation Act was designed to shield Missouri residents and law enforcement from being forced to enforce certain federal gun regulations that the state considers unconstitutional. The law states that Missouri officials, agents, or government employees cannot provide support or resources to federal agencies when it comes to enforcing federal gun laws that the state believes infringe on the Second Amendment. This law even went a step further by creating a civil remedy. Under Second Amendment Preservation Act, any Missouri resident had the right to sue a state or local official who helped federal agencies enforce those federal gun laws. In essence, the state was attempting to shift enforcement power away from government officers and instead empower individual citizens to hold officials accountable if they cooperated with federal authorities in ways that went against the state's interpretation of the Second Amendment. Naturally, this law did not sit well with the federal government. The Biden administration, which was in power at the time the case was first challenged, immediately took aim at Second Amendment Preservation Act. A federal district court reviewed the law and ultimately struck it down in its entirety, siding with the Biden administration. Missouri, however, was not willing to back down. The state quickly appealed to the Eighth Circuit Court of Appeals, asking for relief. Missouri sought a temporary halt to the district court's ruling while the appeal moved forward. But the Eighth Circuit denied that request, which forced Missouri to escalate the fight to the Supreme Court on an emergency basis. When the case reached the justices, Missouri hoped the Supreme Court would step in and pause the lower court's ruling. Instead, the court issued an 8-1 order against Missouri. The only justice who sided with Missouri at that point was Justice Clarence Thomas, who believed the emergency stay should have been granted. With the stay denied, the lower court's decision to strike down the law remained in effect. The case then moved back to the Eighth Circuit, where expedited arguments were held. Once again, the appellate court ruled against Missouri, siding with the federal government and leaving the law invalid. Now, Missouri has brought the case back before the Supreme Court, this time not on an emergency basis, but through a formal petition for review. In its petition, Missouri raises several key arguments. One of the main points the state emphasizes is that the Eighth Circuit itself admitted that the structure and potential operation of SAPA were valid. However, the court still struck down the law because of its Second Amendment purpose. Missouri argues that this approach goes against established precedent, because the court effectively treated the state's decision not to enforce federal law as if it were an active form of enforcement. In other words, the Eighth Circuit essentially ruled that doing nothing, refusing to enforce, was the same as taking action, which Missouri says makes no sense legally or logically. On top of all of this, the case has taken on a new layer of complexity because of political changes tied directly to Missouri. Attorney General Andrew Bailey, who has been leading the state's defense of SAPA, was recently tapped by the Trump administration to serve as co-deputy director of the FBI. He has now announced that he will resign as Missouri's Attorney General on September 8th to take up that federal post. That timing is critical because his resignation will take place before the Supreme Court holds its September 29th conference to decide whether or not to hear the case. This unexpected political shakeup could stall the case, delay its progress, or even shift the strategy Missouri pursues moving forward. So right now, the fight over Missouri's Second Amendment Preservation Act is at a crossroads. The law has been struck down twice, but the state is standing firm, arguing that the courts below misapplied the law and ignored precedent. Meanwhile, the Trump administration has weighed in, telling the Supreme Court to reject Missouri's petition, all while key political figures in Missouri are stepping away at a critical moment. After months of silence and delays, the Trump Department of Justice has finally filed its response in the SAPA case. Originally, the Biden administration strongly opposed Missouri's Second Amendment Preservation Act. But with the new administration now in control, many were waiting to see if the DOJ would shift its position. In their latest filing, the Trump DOJ continued to argue that parts of the SAPA law are invalid. They claim that the lower court's ruling, which struck down the law, was correct. At the same time, however, the DOJ surprised many by adding a new argument. They told the Supreme Court that it should actually deny review of this case and allow it to return to the lower courts. Why? Because according to their filing, they now believe the lower court's judgment may have gone too far. The DOJ stated that, after reevaluating the case, they have concerns about how broadly the judgment was applied. Specifically, they admitted that certain parts of the SAPA law might simply amount to Missouri choosing not to enforce federal gun laws, and under the anti-commandeering doctrine, that choice is constitutionally protected. In other words, states do have some authority to refuse to enforce federal laws within their own borders. The DOJ also raised concerns about how the law would be applied in practice, and whether the provisions that the Eighth Circuit focused on can even be separated from the rest of the Act. Because of those concerns, the DOJ made it clear that when this case eventually goes back to the district court, they would be willing to concede and narrow parts of the judgment themselves, effectively walking back some of their earlier positions. So in short, the Trump DOJ is taking a two-sided approach. On one hand, they argue that Missouri's SAPA law is unconstitutional. But on the other hand, they admit the lower court may have gone too far in striking down the law entirely, and are willing to scale back that ruling if the case returns to the district court. Missouri, however, is not satisfied with this approach. State officials argue that even if the DOJ agrees to roll back parts of the lower court's judgment, the ruling from the Eighth Circuit Court of Appeals will still stand as binding precedent. That precedent, Missouri warns, could harm their case in the future if it once again reaches the Eighth Circuit. For that reason, Missouri insists that the Supreme Court must step in now. They argue the court should not avoid the case, should not deny review, but instead take it up immediately and reverse the Eighth Circuit's decision because it was wrongly decided. Currently, this case is scheduled for the Supreme Court's conference on September 29th. However, there are signs that this date may be delayed. That's because Missouri Attorney General Andrew Bailey, who has been central to this fight and to many other pro-Second Amendment cases, has announced that he will be stepping down from his position and joining the FBI. His departure is a major development, as Bailey has played an active role in defending Missouri's SAPA law and in filing other important lawsuits, such as those against censorship by social media companies. This sudden change in leadership could affect the momentum of Missouri's case at a critical time, making it all the more important for the Supreme Court to take action instead of letting the matter drag on in the lower courts. With Andrew Bailey stepping away from Missouri, it raises a major question about the future of the Missouri SAPA case. His departure could create delays or even cause the case to lose momentum for a while. This is critical because the SAPA law and its challenges are a big piece of the broader fight over the Second Amendment. From what we're seeing, the current strategy by the Trump administration seems to be to avoid pushing this case all the way to the Supreme Court, at least for now. Instead, they may be aiming to keep it limited to the lower courts, where the rulings can be more narrowly applied. As of right now, the case is set for a conference on September 29th. But with Bailey's resignation, there are a few possibilities. The Supreme Court could decide to reschedule that conference, delay it further, or even hold the case indefinitely until things settle. That uncertainty makes it even more important to watch closely, because any move could change the course of how the SAPA case unfolds. Personally, I believe Andrew Bailey would have been an excellent candidate for U.S. Attorney General if circumstances ever brought that position into play. I've known Andrew personally. I've spent time with him and his team, and I can tell you that he truly understands the Second Amendment and the importance of protecting it. He's spoken at major conventions, including events like the GOA's GO-less Conference and GunCon, and he has consistently shown that he's in tune with the Second Amendment community. His move to the FBI as a co-deputy director shows his talent and recognition at the national level, but his absence in Missouri could slow down this critical fight. So for now, all we can do is wait and see how the Missouri SAPA case develops in light of these changes. This is going to be an important story to follow, and I'll make sure to keep you updated as more details come out. If you value updates like this and want to support the channel, the best way to do that is by subscribing. Your support means a lot and I truly appreciate it.